Good morning to all our listeners and welcome to this webinar jointly organized by the China SME Helpdesk and the EU China Business Association, Flanders-China Chamber of Commerce. The topic of our webinar this morning is a comparison between the IP systems of the EU and China. Myself, I'm the moderator. My name is Peter Siegel. I'm working with the China IPsme Helpdesk. And the webinar tool that we are using today is GoToWebinar. Not sure if you're familiar with it. I suppose that everybody in the audience is well aware of different webinar tools over this year and a half in the home office during the pandemic. The important thing about this particular tool is the questions pane, which you can use to send us any questions at any point whenever you have them during the webinar. And our IP expert will be very happy to answer them in the Q&A session after the presentation. So if you have any questions at any point, please write them using the questions pane, and then we will address them one by one at the end of the presentation. A few words about the China IPsme Helpdesk. We're a project of the European Commission, providing free services to interested small and medium-sized enterprises in all European EU member states and beyond. We help companies with IP-related issues in China. We do this through various channels. We have what is basically our main service, an inquiry helpline, where companies can contact us directly, and our IP experts working for the China IPsme Helpdesk can help out with their particular case. This is really a personalized advice, free of charge, of course, as all our other services. And we keep naturally every information we receive from companies confidential, and we only use these information that they give for to help them with their particular case. We also organize workshops like this one quite frequently over the last year and a half, typically webinars, but we're very much looking forward to organizing in-person events as well, now that hopefully it seems like the pandemic situation is easing up and in-person events are possible again. Let's hope that this will be the case in the close future. We also maintain our own website, which is now fully incorporated to the Europay environment, so it's a fully incorporated European Commission website. And we also maintain our blogs, where you can see relevant posts on IP-related issues in China. We typically republish legal articles written by our legal partners, IP lawyers based in China and in Europe as well. And of course, we have a variety of written resources, a few guides, fact sheets, written information, written publications by the legal team of the Helpdesk that can help companies in getting a more general overview of the IP situation in China in a particular area or regarding a particular subject, like patent protection, for example, or using IP in trade fairs. So it's really more of an overall general overview of the services that we provide in a particular area. Here are a couple of examples of our guides and fact sheets. You see they are very easy to understand. They use a very general business language, not IP jargon, and they're visually very well designed, so they're very easy to follow. If you're interested in receiving these, you can find them on our website, and also feel free to get in touch with us at any time. We'll be very happy to send you these guides for your information. The two speakers of our webinar today are Ms. Gwen Song, who's the Executive Director of the Flanders-China Chamber of Commerce and the EU China Business Association, and Mr. Simon Cheetham, an IP expert and the team leader of the China IPsme Helpdesk. So to start with, maybe a few words about the agenda after this general introduction. I will give the floor to Ms. Gwen Song, who will present the services of the Flanders-China Chamber of Commerce and the EU China Business Association and provide a general overview of this event and the rationale behind the event. And then I will give the floor to Mr. Cheetham, who will give a half-hour presentation about the IP systems in China and the EU, and a comparison highlighting the main differences and the main similarities between the two. And as I mentioned already, afterwards, we welcome all of you to ask any questions using the questions pane, and these questions will be answered one by one by Mr. Cheetham. So without further ado, I would like to give the floor to Gwen, Gwen, the floor is yours. Let me know if you need any support with the slides.
Thank you. Yes, it would be good if you could use slides. Ladies and gentlemen, good morning. On behalf of the Flanders-China Chamber of Commerce and the EU-China Business Association, I would also like to welcome you to our 7th joint webinar with the China IPsme Helpdesk. As said, the webinar will focus on the comparison between the European and Chinese systems protecting intellectual property. As a chamber, we attach a lot of importance on IP, and we think that companies doing business with China should also have an IP strategy included in their China business plan. China has already become a leader in innovation in several areas, such as the internet industry and artificial intelligence. And innovation is also one of the reasons why European companies want to be in China, and many European business leaders see Chinese firms also as equally or more innovative than European ones. Speaking a few words about EU-China trade and investment, in 2020, China became the EU's biggest trading partner in goods, overtaking the US, and the EU is China's biggest trading partner. For the first quarter of this year, EU investment in China increased by 50% compared to last year, reaching $2.34 billion. The investment mainly came from the automotive sector, basic materials, and healthcare. Speaking about Chinese investment in the EU, the value of completed Chinese investment in the EU for the first quarter of the year dropped to $500 million. The top sector of Chinese investment was automotive, followed by transport and infrastructure and ICT. According to the IMF, Chinese growth will be at 8.2% this year, which is still the highest in 10 years. At present, one of our big challenges for companies doing business with China is still the fact that companies cannot go to China despite the COVID-19 pandemic, despite the ongoing vaccinations. During these difficult times, the EU-China Business Association and the Flanders-China Chamber of Commerce act as an important bridge to promote the economic and trade relations between China and the EU. So before ending, let me mention a few words about the EU CBA. The EU-China Business Association is the association of bilateral China business associations. In Europe, today we have 20 member associations and represent more than 25,000 European and Chinese companies. In normal non-COVID times, hopefully next year, we will start to receive again high-level Chinese delegations and introduce them to member companies, and we also organize high-level meetings between European and Chinese authorities. The Flanders-China Chamber of Commerce is a leading member of the EU CBA. We are set up by the largest investors from Belgium and China, such as Ageas, Agfa, Bekaert, Barco, Picanol, Umicore, and so on. Our aim is to help Belgian companies expand in China and to assist Chinese companies doing business in Belgium. We provide a China Business Weekly newsletter to keep you up to date on China's economy and trade. We organize, for the time being, webinar on how to and how not to do business with China and give expert advice. As said, normally we also receive many delegations, so we work online and organize also business matching meetings as we have built up a large network in China that we would like to share with you. I would like to end here and mention that we are at your disposal for any further information. We also welcome you for an online talk on how we can further assist you with your business with China. Thank you.
Thank you very much, Gwen. And then I would like to give the floor to Mr. Simon Cheetham, a distinguished IP expert and also the team leader of the China IPsme Helpdesk. Simon has vast experience in IP-related matters in mainland China and Hong Kong as well, along with various other parts of the world, most notably the Middle East and North Africa, where he has conducted quite few due diligence investigations and business screenings over the last 20 years. So thank you very much for accepting our invitation, Simon, and the floor is yours. I will try to give you control over the slides. You should have it. Please let me know if you can move the slides.
Very good, thank you, Peter. Yes, I have just clicked and found I've got good control of the slides, so thank you for that. Good morning,
Perfect. I'll
everybody.
mute myself. Sorry, Simon, I'll mute myself, and if you have any technical problems, let me know.
Thank you. Thanks very much indeed. So good morning, everybody. I'd just like to add my thanks to Gwen and our appreciation. As Gwen has mentioned, this is the 7th joint webinar that the China IP Helpdesk has held with the Flanders-China Chamber of Commerce, and we highly value this this collaboration. So this morning, I have put up the first slide, which outlines the topics I would like to cover during our presentation. The main point of the presentation is a comparison between China and EU on intellectual property. But to set the scene for that, it's worth taking a few moments to look at the current IPR regime in China, and as Gwen has spoken about, the drive for innovation there. We'll round things up with a case study, and then provide perhaps a few comments and tips on IP issues that it's well worth taking with you if you're considering working in or with China. So moving on to our first slide. You can't look at one market in isolation. Goods and information flow quickly from country to country. Much has already been said about the Chinese economy, including about software and China's green transformation. I think we're all well aware that China is now the largest exporter in the world. And China is by far the largest market, for example, for electric vehicles. So the first giga battery factory that Tesla built outside the USA was in China. But China needs continued growth to become a medium level country in terms of GDP per capita. And that means China needs to double its 2020 GDP again to achieve this status by 2035. And with a top-down government, China has set out its 14th five-year plan centering around the dual circulation strategy, first articulated by President Xi Jinping in May 2020, as China began to plan its post-pandemic economic recovery with growth driven by strong domestic demand and combined with exports based on advanced manufacturing. Chapter 5 of the plan describes plans for building a digital China with 7 core industries at the fore. And those include cloud computing, big data, the Internet of Things, the industrial internet, blockchain, artificial intelligence, and virtual and augmented reality. And 10 areas where such technologies should be applied, including smart transportation, smart energy, smart manufacturing, smart medicine, and smart government. So in this context, changes are being made to IP laws in China, which is leading to a steady upgrading of the IPR regimes. And the two main factors which seem to be driving this change are accession to trade agreements, particularly the World Trade Organization, trade-related aspects of intellectual property rights, or TRIPS, and bilateral trade agreements to enhance growth through trade, but also a recognition that innovation is key to increasing value, another key component of growth. Innovation can only flourish under an effective IPR regime. It's worth noting that there is a focus on employing China's fast-growing domestic market and its powerful regulatory regime to decrease reliance on foreign technology and to develop indigenous technologies that will enable China to solve its environmental, infrastructure, and social issues, and as a result, enhance both its economy and national security. Indigenous innovation in China is seen as enhancing original innovation through co-innovation and re-innovation based on the assimilation of imported technologies. The China government has warned against blindly importing foreign technology without plans to transform it into Chinese technology. And the concern is that the importation of technologies without emphasizing the assimilation, absorption, and re-innovation is bound to weaken the nation's indigenous research and development capacity. So with this in mind, let's take a look at China's IP regime. And the theme here is big developments. We've seen a restructuring of the IP registration, management and enforcement government bodies in China, which was part of a bigger reorganization announced during China's two sessions meeting in March 2018. And they have merged together with the State Intellectual Property Office, the China Trademark Office, under the China National Intellectual Property Administration, or the CNIPA. This overall seems to have been beneficial. Greater resources are being brought together to handle and enforce IP cases, as registration and enforcement are being handled by one body. And we can now expect, and indeed we are seeing, a more unified institutional approach from the different bodies dealing with IPR in China. You can see other changes highlighted on this slide, but even more recently, in October 2020, the China's National People's Congress published the amended patent law, which came into force on the 1st of June 2021. And this introduced major changes with regards to invention and design patents. The protection period for design patents is extended from 10 years to 15 years. And one of the main reasons is that it would allow China to eventually join the Hague system regulating design rights, which requires a minimum protection period of 15 years for design patents. The amended law allows companies to register partial designs, which has been a common practice in the EU and indeed in the USA. But partial designs were not previously recognized in China, where design patents could only be obtained when applied for together with a product. The amended law also increased the amount of damages that can be claimed for patent infringement, and the statutory damages were increased to 5 million renminbi, and punitive damages added for cases of severe bad faith infringement, forcing the infringer to pay up to 5 times the damage caused. Also in November 2020, the National People's Congress passed the latest revision to the copyright law, which again came into force on the 1st of June this year. And the amended copyright law contains a provision allowing for the shifting of the burden of proof from the copyright owner to the infringer in the case of where calculating the damages, with statutory and punitive damages matching the new patent law. The amended copyright law moves closer to the open-ended concept of copyright found in many countries with a strong civil law copyright tradition. And it's also adopted a broader open-ended list of copyrightable works. So moving on to take a very quick look at the information gleaned through inquiries received at the China IP Helpdesk. You can see the different kinds of issues which have tended to register the most with businesses trying to do business in or with China. But in addition to this, in June last year, the European Union Chamber of Commerce released the European Business in China Business Confidence Survey 2021. And according to that report, the EU companies operating in China have seen continuous progress on drafting and enforcing of IPR-related regulations in China. The sentiment is that there has been significant improvement in IP protection laws and enforcement over the past decade. And in fact, the highest positive sentiment rate has been seen in this survey since 2012. So as far as intellectual property rights in China are concerned, the outlook has been looking increasingly positive. So enough perhaps said about the background in China, and time to move on to draw a direct comparison between intellectual property in China and IP in Europe. If we take a look at the regimes side by side from an overview, we can see that in general, in China, only registered intellectual property rights are protected. So if you have not formally registered your intellectual property in China, then you cannot enforce those rights in China. And although copyright does not need to be registered in China, registration is available and is advisable, as Chinese courts require registration of copyright or notarized proof of copyright in order to accept your case. When you compare this with the EU, under certain conditions, proof of earlier use in European country markets is sufficient or might be sufficient to enforce unregistered intellectual property rights there. In China, your intellectual property is only protected from the date of registration. In other words, you can only start enforcement procedures once formal registration has been published. Whereas in the European Union, conditional protection is granted from the date of filing. You can start enforcement proceedings for your intellectual property rights as soon as you have filed your application. But if the IP application is rejected in the EU, your enforcement efforts are not recognized. Or if they're partially rejected, the scope of protection granted might be reduced. In China, in fact, globally, intellectual property rights are territorial. And I'd just like to emphasize that Taiwan, Macau, and Hong Kong have separate intellectual property systems. And IP that's only registered in mainland China is not protected in Taiwan, Macau, or Hong Kong. In Europe, this means basically that intellectual property rights registered in a European country is only protected in that country. And the protection does not extend to China. So if you have registered in the Netherlands, you are not entitled to protect that intellectual property in China. Patents and trademarks in China can be extended internationally. China is a party to the Patent Cooperation Treaty and the Madrid system administered by the World Intellectual Property Organization. And this can simplify the international extension procedure for patents and trademarks. And in Europe, of course, patents and trademarks can be extended internationally too. The registration processes in China and in the EU are obviously different. You register with different bodies, and so that is certainly worth bearing in mind. If we take a closer look then at the different kinds of rights and compare them between the EU and China, I think the first thing perhaps is to understand that in China, it's a question of scale, both for trademarks and patents. In 2020, for example, there were over 5.7 million trademarks registered with the CNIPA. And there were some 7,500 applications for international registration via the Madrid system from domestic applicants in China. So there is a huge scale of trademark applications going on in China. But taking a look at the different regimes and comparing the two, in mainland China, visual and sound trademarks are recognized. In Europe, visual, sound, and scent trademarks are recognized. So this is an additional feature of the European regime. In China, registration of Chinese translations of a trademark is something that you should consider and is something that we would certainly recommend. It's not required by Chinese law, but it is certainly useful to translate trademarks composed of words into Chinese in order to be better protected, as well as to appeal to customers in China. There are three common ways of choosing a trademark name in Chinese, either through translation or through transliteration, or by combining both methods, translation and transliteration. And the best trademarks are those that sound the same and also make reference to some sort of defining characteristic of the brand or have a positive meaning in Chinese culture. In Europe, European trademarks do not require translation into other European languages. Again, turning back to China, the international registration through the Madrid system is possible, and this is the same as in Europe. You can register your trademark in China either directly with the CNIPA or through the Madrid system. But be aware that because China divides goods and services to further subclasses, it's not advisable to use the Madrid system filing route for very complex trademark applications without first consulting a local trademark agent or IP professional. So just be cautious with the trademark registration procedure. China uses the international classification of goods and services, but as I've mentioned, it does make a further subclass division. Whereas the European Union simply uses the international classification of goods and services. So let's take a look at the patent regime in China compared with Europe. Registration in China takes less than 1 year for utility model patents and generally 3 to 5 years for invention patents. Invention patents are valid for 20 years and are normally granted, as I say, within 3 to 5 years. Utility model patents are a faster, simpler form of patent, and they are normally granted within around 1 year and are valid for 10 years. In Europe, in the time it takes to register an invention patent really depends on the individual EU country. The next issue to be aware of is that invention patents which are made in China need to first apply to the State Intellectual Property Office for a confidentiality examination if the first application is to be made outside of China. If you don't make this application, it's not possible to obtain a valid patent in China. Whereas in Europe, there is no such mandatory confidentiality examination. And the next point is well worth emphasizing, and that is that utility models are widely used a form of intellectual property right for inventions in China. Utility models are new technical solutions which involve the specific shape and or the structure of a product, which are fit for some sort of practical use. Utility models, as I say, are granted faster and require no substantive examination. And utility models are much less common in Europe. You need to check with the individual national intellectual property office in Europe, because not all European Union countries offer this form of protection. You can obtain patent rights in China by filing an application directly with the CNIPA, or alternatively, you can use the Patent Cooperation Treaty filing route. The PCT route gives you 18 months time to consider the viability of your invention in China. So in a sense, you are gaining some additional time before going down that route if you use the PCT filing route. Be aware that the Patent Cooperation Treaty route is not available in Taiwan or in Macau. Of course, the Patent Cooperation Treaty filing route is available in all EU member states. I wanted to just say a few more words about patents in China, and particularly on the subject of parallel filings of utility model patent and invention patents, which is commonplace in China. In this way, an applicant benefits from the early granting of the utility model patent, as well as from the long-term protection of the invention patent. And once the invention patent is granted, the utility model patent has to be abandoned. But to give you some figures, in 2020, the CNIPA authorized 530,000 invention patents, bringing the total number of patents granted in mainland China, remember this excludes Hong Kong, Macau, and Taiwan, to 2.2 million. And the number of invention patents per 10,000 people reached just under 16, which exceeds the targets expected in the outline of the 13th China National 5-year Plan. In terms of utility models and design patents, in 2020, 2.3 million utility model patents and 732,000 design patents were authorized in China. So many Chinese businesses make widespread use of the utility model applications, and it is well worth being aware of this the availability of utility model patents in China if you're looking at doing business there. If we take a look at some of the other rights in China and compare them to Europe, designs need to be registered as design patents in China in order to be protected, whereas designs can be protected either as unregistered community design or as a registered design in Europe. As mentioned, the registered designs in China are protected for 15 years, and unregistered designs are not protected, whereas registered designs in Europe are protected for 25 years. So a registered design in the EU gives you the exclusive right to use or allow others to use it for 25 years in the whole of the EU or in the state where it was registered. In terms of copyright in China, copyright is protected from the date of creation. You do not have to register a copyright to enjoy protection. However, registering your copyright is an option in China, and it is recommended in order to prove ownership. And you can register copyrights at the Copyright Protection Center in China. That's the CPCC. In the EU, only a few EU member states provide copyright registration to provide proof of ownership. You should keep a record of authorship and a date of the establishment of the work of art in order to enforce your copyright in Europe. In China, databases can be protected with copyright as a compilation works, and databases can be protected in the EU through copyright if they are original intellectual creations. So there are some technical differences between the two. If you're looking to protect algorithms and 3D printing CAD files, for example, in China, algorithms that are integrated into the source code of software are protected by copyright in China, whereas you can also include 3D printing CAD files, which are also protected by copyright in China. Yes, a quick word on trade secrets before I move on to the next slide. In China, trade secrets need to be protected by physical, technological, and contractual measures in order to be protected. They need to be protected in accordance with the Chinese anti-unfair competition law, otherwise there will be no protection. In Europe, on the other hand, until 2016, there have been no harmonized laws relating to the protection of trade secrets at the EU level. So as a solution to the standardized trade protection within the EU, there was a new directive on the protection of undisclosed know-how and business information against their unlawful acquisition and use. And this was adopted in June 2016. And member states have since been required to bring into force laws and administrative provisions necessary to comply with the directive. Overall, the EU directive aims to harmonise national laws concerning trade secrets by ensuring an equivalent level of protection of trade secrets throughout the EU and introduce a uniform definition of the term trade secret. But in China, I think that the points to be aware of are that in order to be protected as trade secrets, they need to be undisclosed to the public, so they need to be held confidential. They need to provide some sort of competitive edge or economic benefit or commercial benefit, and you need to be able to demonstrate that they have been protected by either physical or technological or contractual measures. And you need to establish these 3 points in order to protect your rights as trade secrets in China. So those are the key rights that we have taken a look at. Now to take a brief overview of the differences in enforcing intellectual property rights between China and the EU. I think one of the key points to note is that in China, the intellectual property rights holder generally carries the burden of proof. So it's the responsibility of the IPR holder to collect evidence to present in court in the majority of cases. And as foreigners, we need to be aware that all evidence has to be notarized by Chinese notary public, otherwise it will not be accepted. There are now certain provisions, for example, according to the revised trademark law, where under certain circumstances, the infringer can be ordered to provide evidence or additional evidence by the court. In Europe, we have a somewhat different approach. The courts can order the infringer to provide relevant information and evidence. And in Europe, the courts can help the intellectual property rights holder collect evidence by ordering the suspected infringer to provide relevant information and evidence. So there is a difference in approach between China and the EU in that respect. In China, the court determines the time limit for producing evidence in the pre-trial preparation phase, whereas in Europe, evidence can be presented during the whole of the court proceedings. In China, you can enforce your trade secrets in court and with the administrative authorities. So trade secrets are not only protected under civil and criminal law, but also under administrative law, at least in theory, in China. Whereas in the EU, trade secrets are protected under civil and criminal laws. They are not protected under administrative law. In China, you have the resources available to you to take administrative actions. Administrative bodies offer a relatively fast and cost-effective way to deal with trademark and copyright infringements and to gather evidence for patent infringements. Administrative authorities are authorized to carry out raids, to confiscate infringing goods and impose fines on the infringer. However, they can't award compensation for damages. Online copyright infringements can be dealt with in the internet courts in China. There are internet courts in China, for example, in Hangzhou, in Beijing, in Guangzhou, and they have jurisdiction in online copyright infringement cases and usually are faster and more efficient in solving this type of case. Proceedings for each case are handled by these courts from lawsuit filing to verdict announcement will be made available online, saving you from traveling costs. And the Supreme People's Court of China has published a provision in 2019 allowing them to accept evidence obtained electronically, such as through blockchain. And it is on the topic of blockchain that I wanted to just talk very briefly about a case that we dealt with, because it kind of helps demonstrate the value of this new means of presenting evidence. The China Helpdesk had an inquiry from a particular SME. This involved a Polish photographer who went to Hangzhou to study Chinese language. And then took up photography and took many photographs, ultimately exhibiting some of his work in some exhibitions, as well as licensing some of the photographs he took to some magazines and travel agents. And this success motivated him to open a photography studio in Poland and later establish a branch in Hangzhou. And he was able to obtain contracts both in EU and in China. But having established his company, he discovered in 2018, there was a new method of intellectual property rights protection, the use of blockchain. He found private companies that provide the service of including any information, for example, a photograph, in a blockchain. And this is more affordable than voluntary copyright registration for every image, and provides a timestamp proving when the picture was taken. Blockchain also allows a record to be made of all the metadata of each picture, such as the camera model, the white balance, the ISO, aperture, shutter speed, photo editing software used, and so on. And he adopted this service as part of his regular protection mechanism for published and unpublished works. And it was very fortunate because in 2019, he discovered a Chinese photographer from Beijing was presenting his work as her own, and even had a full website using pictures from his portfolio while offering similar services. And I understand the infringer had also managed to participate in some exhibitions too. He was not in a position to afford a long judicial copyright pursuit with the infringer. They were initially looking for some alternative dispute resolution methods to start negotiations and send a cease and desist letter. And they tried, and they did send a letter which was simply ignored. And eventually his Chinese lawyer recommended filing a case in the Hangzhou Internet Court. And the Internet courts, as I've said, have jurisdiction in online copyright infringement cases, and they're usually faster and more efficient at solving this type of case. The case was presented to the Hangzhou Internet Court, and the blockchain protected evidence of copyright was presented alongside the blockchain record of the Chinese photographer's website. The entire judicial dispute took just 1 month. All the proceedings were online. And when the hearing came up, it was a brief hearing. The whole hearing lasted 28 minutes. The Polish photographer didn't need to travel. And a few days after the hearing, the judgment was presented by the court. And the Hangzhou court ruled in favor of the Polish photographer. It accepted the blockchain as evidence and reached a conclusion that there was a copyright infringement. Photos were taken down from the website, the infringing website, and damages were paid to the Polish photographer. So the takeaway messages from this is that blockchain technology can be used to record online evidence. It's an alternative way to prove copyright in the case of published and unpublished works, and it provides a timestamp, and the internet courts in China are already accepting this as evidence. They're also an efficient, the internet courts are an efficient way to solve these kinds of online copyright disputes in terms of times and costs. But at the moment, they can only be used for online copyright infringements. It would not have been possible to use this method if the infringements only concerned physical exhibitions and not the website. So just be aware they are aimed for online infringements only. I'm conscious that we are running on in terms of time, so I had a few extra remarks that I wanted to make in relation to doing business in China. So I'll just very briefly run over these. One of the issues that often arises when we are talking to businesses is what's the safest way to get into the China market? And the simple answer is, if you are an SME or running your own business, the safest way to enter the China market is really to follow, if you have an EU customer, to follow your customer there. For example, if you're a supplier to some major corporation which is opening up in China and would like you to continue supplying the products or services, then the ideal way would be to follow that customer in. This allows the greatest degree of protection and control over how you enter the market. Setting up a wholly owned foreign enterprise is more difficult, but also less risky than some other ways of entering the China market. Setting up a wholly owned, wholly foreign-owned enterprise is obviously a more investment intensive way of entering the market, and it's not always feasible for smaller businesses. As you move further up the scale, entering into a joint venture increases your exposure to risk, because it is very difficult to establish a rock solid collaboration in a short period of time. You really need to spend time and take a number of very specific steps before entering into joint venture arrangements. And finally, licensing your technology to some unrelated company in China, for example, it may be in a contract manufacturing context, is a more risky again, because you generally have the least control over your intellectual property when you're dealing with other companies in an arm's length way in this fashion. So just be conscious about the way in which you approach the market, and it takes time and effort to do this correctly. This slide is really aimed at encouraging businesses to consider how they will deal with intellectual property during the way that they interface with all the different aspects of their business. Protecting intellectual property, for example, while having to deal with contractors or partners or regulatory authorities and a host of other parties, is a constant challenge, and it does require planning and care. It is not something that you can do overnight. I'm just going to skirt through the last couple of slides because I fear we've somewhat run over the time allotted. I wanted to emphasize the importance of taking your time to find the right business partner, if that's the approach you are looking to take when doing business in or with China. Look to put in place certain measures to ensure that you retain control over your know-how, over your intellectual property, over the essence and the core of your business activity, so that you are able to maintain your business in China successfully over the longer term. And you can take this through adopting a number of pre-planned steps, and some of these have been outlined in this particular slide. These slides will be available to you after the presentation as an aid memoir, if that is helpful for you. And I should add the importance of non-disclosure agreements cannot be or I should say can't be overestimated in your dealings with businesses in China. Always use non-disclosure agreements when you're dealing with businesses entering into a new business relationship. It is not true to say that businesses would consider it a loss of face, or that you would turn away a legitimate business interest by insisting on having these agreements in place between you and your collaborative partner. Good business practice is good business practice wherever it is in the world, and that is no less true in China. If a business is unwilling to enter into these contracts and agreements with you, then you should really think carefully about whether or not you are dealing with the right business, and it's in your interest to maintain that relationship. And I think this is the last slide. A quick word on some other issues relating to licensing and tech transfer. First thing to say is that often EU businesses do not use correct contracts for tech transfer. For example, clauses that keep technology confidential and clauses that regulate what happens to technology are often forgotten. You need to have more detailed contracts for this. And also many EU businesses tend to put the wrong governing law clauses into contracts. For example, it may be that the contract is enforceable under French law. And the problem is that Chinese courts respect this and will not take cases if Chinese law is not applicable. And also, Chinese courts do not accept execution of a foreign judgment in China. So make sure that if you're dealing with a Chinese business, that the correct law is applicable to the contracts that you make with those businesses. You want a law that is enforceable where the business activity takes place, in other words, in China. China's copyright law recognizes contractual terms for determining ownership of new intellectual property rights generated or derived from licensed rights. So it's very important to address ownership issues in license agreements. Be aware that commissioned intellectual property belongs to the commissioned party unless the contract states the commissioning party owns the intellectual property. So it's important that contracts state clearly what intellectual property is to be developed and who will own it. And improvements owned by a party that makes them in China. This is a requirement and cannot be automatically granted back to the other party without some sort of compensation or reciprocation, such as granting a license to the other party's improvements. And finally, the Chinese party cannot be restricted from making improvements to transfer technology and using them. So any restrictions will be unenforceable. I perhaps should add that reverse engineering is in a sense, it's permitted under Chinese law and not considered a theft of trade secrets per se. So you really need to have well-drafted technology transfer contracts, which should include a provision limiting or prohibiting from engaging in reverse engineering as well. These are topics that would require some hours to discuss in detail. So my apologies for rushing through them. I just wanted to pick out a few points and try and highlight issues where there are differences between the EU and China, and I hope that has been helpful to you. But now I'll wrap up and perhaps open the floor if there are any questions or if I can provide any additional information. Please feel free to ask. Thank you.
Thank you very much, Simon. We received a couple of questions from the audience. First of all, if we could send a list of the main comparisons by email. And secondly, if we could, okay.
Yeah, sorry, Peter, I was just going to say, yes, I think we could share the slide presentation and that and summarizes the key differences. There is further information, of course, on the China Helpdesk website, which will give you further detail on the differences between the EU and China IP regimes. But as a starting point, I think we would be happy to share the slides that have been presented this morning, and which I hope will help.
Perfect. Thank you very much, Simon. And the second question we had is if we could suggest a contact information for an internet court in Zhongshan district. If maybe the original poster could give us a bit more information where this district is. I'm assuming this is the district in maybe Beijing or Shanghai.
Right. This is one of the three. There were three internet courts. Hangzhou is one of them. To give you, I don't have it off the top of my head, but I'm sure we can send that information through. So if we have contact details for the person raising that question, then we would be able to respond and send that information. I think that would not be a problem.
Perfect. Then we would be very happy to get back to the original poster and send this information via email. Also, we'll be happy to send the slides to all the participants via email in a follow-up email after the webinar. Another question that we just received. Maybe it's easier if I just read it as it is. Thank you for the great explanation. What is the case? What is the recommendation in case when someone in China is already registered? So sorry, someone in China already registered your trademark, but not your official logo.
Right. Yeah, this can be a challenging issue that a number of European businesses have faced. I'm not sure if you have already registered any rights in China. It sounds as though your logo has not yet been registered, so you may want to file an application as soon as possible for the logo. In terms of the I presume it's a word mark, the other aspect of your trademark, I'm not clear whether this has been registered or whether you're aware that an application has been made to register that mark. If it's an application, then you may be able to challenge the application and prevent the registration, and then there's a procedure to go through to do that. So if the mark has already been registered and you've only just become aware of it, then it is far more difficult to undo the damage in a sense, and in most cases not successful, I have to say. But it may still be possible to prove bad faith if the registration was made in bad faith. And one of the ways to assess whether or not you're likely to have any chance to succeed is to carry out a search of the China Trademark Office in China, and it's open to you to do this, or the China Helpdesk can assist you with the means of how you can go about doing this, to search to establish whether that the entity that's registered your mark has registered other marks which may be in bad faith too. So if, for example, you searched and you found that that particular registrant had applied to register dozens of other famous or well-known marks that are recognizably foreign marks, that may help establish an element of bad faith, and you may then have the beginnings of a case to have the registration cancelled. But if it's a one-off registration, and I have to say this sometimes happens where EU businesses have perhaps collaborated with a supplier in China, and the supplier has on their behalf gone ahead and registered their mark, and then perhaps the association has fallen apart, and the EU SME has gone off to another supplier, but without obviously the registered mark. That situation has cropped up quite often. Then that's going to be much more challenging to undo, and you may have to look at a different strategy, even perhaps considering alternative marks, or looking at the breadth of the registrations that are in place in respect of your mark in China. As I mentioned, China has a subclass system, so there is a very narrow protection focus within the subclass system. So it may be that your mark has been registered in one particular subclass, but you may be able to prevent further damage by applying to register in other classes outside that particular subclass, and thereby limit the damage that has been done. So there are a number of things that you can consider there, but again, the China Helpdesk is here to assist. So if you have a particular issue there and you would like some sort of direct one-on-one advice, then please reach out, just email the Helpdesk, and we will try and provide you with some advice on the appropriate strategy in your particular case.
Thank you very much, Simon. We have another question we just received. It's regarding blockchain evidence. So the original poster is asking whether you think that evidence created with WIPO proof, so this is the European Intellectual Property Office, I'm assuming, the World Intellectual Property Office proof, which provides trusted digital evidence, might be accepted by a Chinese court.
Yes, I would expect it should be. Of course, the issue you will face is putting it into a form that will be accepted by the court in China. So that will present the issue of translations and notarization. But if that is satisfied, then I do not see why that would not be accepted by the Chinese court. So I think before going down that step, I would just double check with your lawyer, your IP lawyer, to make sure that the chances of them accepting in your particular case are good. But in principle, you should be able to present that evidence, as I say, as long as you're able to comply with the language and notarization aspects.
Perfect. Thank you very much, Simon. These were all the questions that we have received, and we have also run out of our time, 3 minutes after past, in fact. So thank you very much for this very insightful presentation, and also for answering these questions that we received from the audience. And thank you very much, Gwen, as well, for the very helpful co-organization, helping us with the organization of this webinar. So if there are no further questions from the audience, then I would like just to welcome you to follow us on our social media, Twitter and LinkedIn. And if you have any questions, then please feel free to write them to the info@china-iprhelpdesk.eu email address, which you can also see on the screen, but the slides will be distributed and then you can see our email address as well. So once again, thank you very much, both to our partners and to all of you for attending. And we will send you the slides in the upcoming days through a follow-up email. And if you have any questions, please don't hesitate to write to us. Thank you very much again, and wish you a very nice day.